The Good to Great campaign started off last year, it was around Stephen's 1818. And the idea around that is to look at young people who are in the middle, because sometimes the kids who are excellent, you get a lot of focusing on them, and the kids who are at the bottom and like the niche, there's a lot of focus on them, but the kids in the middle sometimes get left behind. So the idea around that is to help support them, to sort of move from a D to a C grade. Also, where the trust is concerned about moving to other professions, I think we've done excellent in the work that we've done around architecture as being an underrepresented profession. So by moving into law, because that also is underrepresented within the ethnic community, so we want to be able to support young people in order to get into that profession also.
My association with LSBU, my first association with LSBU was quite accidental. I happened to be a pupil, training contract at a local firm, quite a famous firm, doing cases such as Birmingham 6 and Guildford 4. As a young lawyer, you're looking to make some extra money, and there happened to be a vacancy as a lecturer at London South Bank University, so I started teaching law part-time here and really enjoyed it. LSBU provides a very practical approach to the law, and for me that's critical. That's why I became a lawyer. I was working in community organisations, seeing the real impact of the law on communities. And for me, it's intellectually challenging and interesting to think about the law as some abstract which can be debated in courtrooms. But far more constructive for me, and the career that I wanted to pursue, was how law could impact and change people's lives. And what was very promising and very good as far as I could see, the lecturers and the way that the course was structured at South Bank, was that it gave students the ability to look at the legal profession and the law as a means to change society. And as somebody who's been involved in a couple of cases which have sought to do that, I find that a tremendous achievement and optimism for the future, because what it produces are lawyers, colleagues of mine, people who've been involved in cases I've been involved in, which have moved and changed because of that education. They've been able to take what they've learnt in the classroom at the university and put it into practice. And that for me is a sign of a great legal profession, great legal mind, much more so than the ideological, philosophical value, as interesting as that is about the law.
I'm Andy Unger, for those of you who don't know me, and I'm the current head of the law department. And it's my job to host the evening and to bring you up to date, those of you who've been away for a while, with recent developments in the department. We teach a law degree, as we've always done, but recently we've developed some professionally oriented master's programs, because we saw that many of our students, often before or after the LPC or the BVC, wanted to take a master's, and we thought, well, it's crazy that we're not offering it. And we tried to develop courses that would be useful in practice. So our first initiative was the LLM in crime and litigation, and we've added to that now. We have a master's course in international human rights and development, and we've got some other projects in train. We're constantly concerned with the career opportunities that we create, because that's why people come here. Studying is wonderful, being at university is wonderful, but the reason why everyone comes here is because they're concerned about developing a career for themselves. And we know that qualification into the legal profession is difficult, expensive, and uncertain. And we've done our best, really, to develop our programs in ways that maximize the opportunities for our students to go on into worthwhile careers. Recent developments include a module called Working in the Law, where we concentrate on placements, professional skills, volunteering, and those kind of issues. Those of you who are from an older generation, if you saw it, you would still see the bones and some of the flesh of common law in action. And if you ever acted for Mr. Bean or Mr. Rudd, well, they're still alive and well. No longer played by me. For those of you who do remember, Mr. Bean was a character, not the Mr. Bean on television, but just the name that we gave to a litigant in what had been a real personal injury case. And the original Mr. Bean and Mr. Jones were Mick Jeeves, who's here somewhere, and Andy Boone, who has gone on to become head of the law school at Westminster. We had an alumni event a few years ago, and I introduced him as the original Mr. Bean, and he was a little bit hurt because he'd forgotten about Mr. Bean, the litigant, and he thought I was referring to the television programme. In working in the law, we encourage and support students to take placements. We've got 20 placements with Southwark Legal Services, which is an excellent opportunity for those students who are taking part. But we've constantly tried to expand the professional opportunities for our students, so we've created a legal advice centre. Some of you may have been on a visit to it this evening. I don't have time to tell you about it now, but you can find out more through our website, and you can contact us if you're interested. But we have very experienced practitioners as members of staff who run the centre. They work with student volunteers. It's a drop-in session for the public. We work out if they have a legal problem, what kind it is, and we direct them to the next step. And we have very strong links with Southwark Legal Advice Network. Friends and colleagues from Southwark Law Centre are here tonight. And it's another way in which we are trying to serve our community and foster the interests of our students. Last thing I think that I'll tell you about in terms of recent developments is that we have created a qualification for the Chartered Institute of Legal Executives and put it into the law degree. If you do the LPC and you don't find a training contract, or if you want to follow a career as a legal executive, you can become a member of the Institute without any further study or examinations, because they have a fast track for graduates who've done the LPC. We spoke to them and we said that we wanted to offer that qualification. So we've created civil litigation and criminal litigation options in the law degree. And if you take those options, you've satisfied the ILEX qualification. And as a member of ILEX, if under the current arrangement, everything is being reviewed in legal education, but if under the current arrangement, if you work in the legal sector for 5 years as a member, you can become a fellow of the Chartered Institute. And a fellow is fully professionally qualified in the same way that a solicitor is, but in one practice area rather than all. That's not really a problem, because most lawyers tend to concentrate on one practice area. And with the changes in the legal profession and the delivery of legal services, the ILEX qualification is more valuable. You can become a partner in a law firm, you can become a judge, you are fully qualified. And it avoids, for some students who choose that, the bottleneck of the LPC and finding a training contract. So those are some of the ways in which we're trying to carry on our tradition of being a community law school, serving the interests of our community and of our students. I'd like to take this opportunity just to tell you that we are taking part in the London Legal Walk on the 21st of May. There are some flyers outside. We're taking part with the South London Law Society. We are walking to raise money for a law centre that we support in Zambia and for our own law centre at home. And it's just a request really, but if you wish to walk with us, or if you're willing to sponsor us, or you know those who do, please pass on the word and support us. The other thing that I would like to draw your attention is that we're very lucky to have Doreen Lawrence with us, and we strongly support the work of the Stephen Lawrence Trust, because the aims of the Trust are very similar to the aims of the department, and we would also encourage you to support that Trust. The work is, Doreen's going to tell you more about his work, but I'd like to take this opportunity to ask you to support the Trust. As I said, the first cohort of law students began their studies here in 1973. And we're very lucky to have with us the first head of department, Max Weaver. Max was the founding head of the law department. It had a different name in those days. He went away to higher things, but recently, in his retirement, he's come back to us and he teaches with us. He takes part in the life and the work of the department. He's a visiting professor in the department, and I'd like to ask him to tell us a little bit about life in 1973.
If we rerun an event like this in 10 years' time, whether I'll be able to remember life. I can remember quite a lot of the dates and things, because actually I happened a son who's 40 this year, and he was born just before I came here. And you spend a bit of time, Andy's asked me to sort of look back a little. I can't, it's inevitable on an occasion like this. And I suppose the big thing for me is how much of this is planned and how much of it is accident. There's a lot of my involvement with this institution that there's been accident. I left LSE and went to teach at what became Kingston Poly. Why did I go there? Because I was a trumpet player. And a guy that I used to have coffee with at LSE was also a trumpet player. So we did a few jobs together, and he phoned me up one day, and he was actually starting the law department at Kingston. And he phoned me up one day and said, "Max, you're quite a good player, you'd better come and teach law." so I did, and he did say there would be an interview. Okay, but I seem to survive that. But then I came here 7 or 8 years later, having really already booked a year off, a year sabbatical, not a year off, to write a thesis about intention in the law of tools, which I have to say I'm still struggling with. And they wanted somebody to start a law degree here in the new Polytechnic. And they had a bit of hadn't worked before, so they wanted somebody who'd been involved in one. So I applied and I got it. I remember at the end of the interview I was called back in, and the then director of the Polytechnic, Mr. Pereira Mendoza, said to me, "Mr. Weaver, we'd like to take a chance on somebody as young as you. And would you accept the job?" I said, "Now you give me a real problem, because I've got this sort of academic plan and or the thing of doing something in legal education." He said, "Mr. Weaver, we're not interested in your deeper thoughts, your inmost soul. We just want to know whether you're going to take the job or not." Now, I took it. I should have enough to put you off, really, but. And it was a wonderful opportunity, because we were able to build here something new and different. What was going on in the legal education world in London at that stage was boring. It was black letter stuff. And in the new university, the Polytechnics and the universities, what were they doing? They were carving up the external London law degree and sending it off to the Council for National Academic Awards and saying, "Please give us the right to teach for this degree." And it was really as stultified as that. The developments were actually on the other side of the Atlantic and in the Antipodes and in continental Europe in some ways or another, and in other disciplines. And we were only allowed, because it's a planned economy in those days, we were only allowed 30 students. So I said, what we'll do is something different. There is no point in a mere 30 students starting at South Bank. You could put one in each London institution, no cost, no point, unless we do something different. So it was a license to indulge my academic fantasies, as it were, or my cares, my concerns. And the law degree that grew up said very clearly that you cannot understand law simply by looking in law books. You get a degree in law, you're supposed to be able, you don't necessarily have to know every bit of the law, but you are supposed to be able to understand the dynamic of the subject that you have a degree in. The way it changes, the way it sits in the world. And we began to work, so it was an academic drive. But in order to drive things along academically, we had to deal with this problem of law in the books and law in action. We also dealt with law in context. We built up associations with sociologists and things. And if Mick Jeeves was speaking today, he would make fun of some of the German names that I used to use and so on, because there are ideas there that we use. But the crucial things that have become continuities, I think, are the involvements with practice. We started the idea of legal method here, and then we turned it into exposing people to clinical experience. You say to a student at was then the Citizens Advice Bureau in Streatham, look at that file, there's a letter from the insurance company. You know about the law of negligence, draft a reply. And the student will be totally unable to cope with that at first, because facts and money and time and procedure, all these things impinge on it. And we've actually worked our way through all that. Then with the great simulations, which Andy's picked up on Mr. Bede and Mr. Boone and so on, and also then clinic, which died a death, but has been resurrected, I think, better than ever, and I think that's truly a great achievement. So you've got these kind of continuities. Along the way, you've got a discontinuity, I think, which is really quite significant. We were able to take our time and indulge our own in our own thinking and our own ideas to a greater extent than the modern new university world allows. The emphasis on vocation, vocationalism, on training for jobs has a tendency to restrict an ability to engage with wider things. And that's a matter of regret. I also think it's slightly short-sighted. Some of the best ideas come from thinking broadly and then bringing them together, focusing on people, their experience. One continuity and I'll finish because we have somebody much more interesting to listen to, is the localism of the organisation. That's diminished somewhat, but this organisation and this department has still got its roots in inner South London. And so one of the things we were trying to do when we started here was to make a law degree rather than a law department to start off with, which would be accessible, open, useful to local people. We saw ourselves very much as a neighbourhood law school. We saw the Polytechnic saw itself very much as a neighbourhood organisation. Now, some of that has diminished. The need to be competitive nationally in Guardian League tables, Times League tables, and to keep the Higher Education Funding Council happy, but diminished that. But it's still there. It's noble, it's honourable, it's worth hanging on to. And I know that Andy and staff here do care about it. And it's quite clear from the few people that we're meeting with upstairs that it's still powerful. And there is something for this organisation and this part, the law degree and the law department, to do in this locality. The needs, sadly, have not gone away. Our ability to address them is limited, but I think we continue to do our best with that. So I hope that's some kind of bridge between the dark ages back in the 1970s and the bright modern world that we have now with Mr. Cameron in charge. There we go.
We're very lucky to have two excellent speakers who've kindly agreed to speak tonight. And the topic that we've chosen is the Stephen Lawrence case. It's something that mattered to, I think, probably everybody in the room. It's something that has changed the face of criminal justice in this country. And Imran Khan is a visiting professor here. He's been associated with the law school for a long time. He's going to talk about the legal case and the Macpherson inquiry and recent developments. And Doreen Lawrence has very kindly agreed to join us to talk about the legacy of the case and the work of the Stephen Lawrence Trust. Imran's going to speak first.
Is that working? Can you hear me? Can I thank you for inviting me to speak? It's a real honour to be speaking on this occasion. I've got a long history of association with South Bank. When I was, what was it called back then? Training contract now. What was it called back in the dark ages?
Article clerk.
Article clerk, that's right.
I was an article clerk.
I was an article clerk at a firm in Bernberg Pearson Partners, which was up the road, London Bridge. And as an article clerk, not earning much money, much less now, I suspect, and decided that I would take up teaching. And the closest university was this one. So it was a bit by accident. So I started teaching here. I think I did it for a few years and kept up an association with the university. And I was such a good teacher. I'm not blowing my own trumpet here. But some years later, when we set up practice in East London, there was a local Italian delicatessen that opened that supplied sandwiches to all the staff at the firm. And I walked in, and there was my star student. He was the one that opened this. He'd gone away from law and opened up a business, and he was incredibly successful. So that's my success. Completely changed his career from law to business. The only good thing about that, we got sandwiches at 50%. From then on, I've kept in touch, and it's no coincidence that three lawyers on the Lawrence inquiry had an association with South Bank University. And I think that's a testament to the sort of commitment that this university has to community law. I didn't come to this university. I went to a university which will remain nameless in East London, the University of... and I was very lucky because I had lecturers there who I suspect, as part of the polytechnics of that era, were talking not just about some philosophical basis for law and having some abstract view about contract and equity, etc. It was a very practical grounding. And the lessons I learned there were looking at judgments and looking and reading between the lines, whether it's contract, crime, etc. Reading between the lines and reading things like Politics of Judiciary by J.A.G. Griffiths. It was those things which influenced my outlook on life, and it was great to see that is continuing with this university, which is why my association continues, apart from the fact that I'm contracted to be a visiting lecturer and professor. My mum's very proud of that, by the way. That's by way of introduction. Sorry, I may take a bit of time. I've done something formal for today, and it is Stephen Lawrence case, its impact and legacy. I want to talk about its impact. And Doreen and I have been in a double act now for many years, 19 years. So we haven't exchanged our presentation today, so there may be some overlap. And I'm going to do it from a legal perspective, and Doreen will do it from hers. I apologize in advance because in 19 years I've accumulated so much information about this case that I can talk ad nauseum. I have talked ad nauseum about this topic. And I've concentrated on certain aspects. So forgive me if certain things that you wanted to hear from me are not in here, and things which are not that you didn't want to hear are here. It's my take on this, and I hope you'll certainly enjoy listening to it. Everyone tells me not to start with a joke, but I'm going to start with a joke. It just shows how bad I would be if I were a comedian, but I start with a joke. Nicolas Sarkozy, Vladimir Putin, and David Cameron happened to be visiting an art gallery when they come across a painting showing Adam and Eve in the classic repose that all of us have seen. They begin to discuss the identity of the painter. Sarkozy says that the painter is of French origin. The painting shows a romantic scene full of love. Putin says, no, the painter must be of Russian origin. The two are sharing what little they have, equally between them. Cameron, however, is convinced that the painter is British. Pressed as to why he thinks so, he states that the two are half clothed and half starving, yet they still think they're in paradise. I'm glad I got a laugh. I tell you that to illustrate a point, a more serious point. The punchline
it's only effective if the audience, that's yourselves, are in on the joke. Namely, the nature of Britain or the British or those who are viewed as British. It's to illustrate the point that there are certain views of the British or Britishness which are held by different parts of the community. And I don't know whether you recall the riots up in Bradford and Burnley, but after that occurred, a man from Burnley was quoted in one of the newspapers saying, "Racial attacks, that's what Britain's all about, isn't it?" And to many in the black communities, that's what this country epitomises, the perception they have of what is at the heart of our society. To these individuals, notions of diversity and multiculturalism are meaningless epithets designed to cloak the reality that we face on a daily basis. In one sense, if you want to draw up a profit and loss account about what life was like in '93 when Stephen was murdered, or what it's like now, little has changed apart from perhaps you might think some of the terminology. We were colours within Asian, Afro-Caribbean. We're ethnic minorities, minority ethnic communities, visible minorities, people of colour. And now we are part of a diverse community. For my part, coming as I do from a community activist point of view, I always thought the most appropriate term to describe us was the black communities, because to treat the issue on the basis of ethnicity alone is to view it in apolitical terms. Yet the question of race is nothing more, nothing less than political in nature. And I don't know whether you've read anything about the US, but there are newer and newer phrases to describe the black communities. Yet on the other hand, only a few years ago, the prison population in the US, the black prison population, went beyond the 50% mark. And so there is this contradistinction. And the fact that these people were now called people of colour made not an iota of difference of their daily lives. The point that I'm trying to make somewhat clumsily, you may think, is that the past few decades, indeed the past 19 years, have seen attempts at integration on a ethnic, multicultural level, not at a political level. We have allowed ourselves to be ethnicized, believing that to be the route to our acceptance. Understand who I am, and you will accept who I am. In my view, that has failed abysmally. In my view, today's concept of diversity has masked the reality that exists and suggested progress when there has been little, if any. And what progress there has been made, in my view, has taken place in no small part to the determination and courage of one family and one person in particular, Doreen Lawrence. Her journey on that date and mine, inextricably linked, hers in the most tragic circumstances occurred on the 22nd of April 1993. And I pause and digress slightly. I was, I think, in this room, or one of the smaller lecture theatres, about a year ago, before the trial of Stephen Lawrence's killers took place. And I mentioned the name Stephen Lawrence. And as I looked across the audience, there were quizzical faces. There was a generation of individuals at this university who'd never heard the name. We've had much publicity since then. And it occurred to me that there's a generation who don't know the facts of the case, and that that iconic image has become a byword for injustice without knowing what the reality was. But imagine, and I can still to this day, it was a Friday afternoon and I got a call while I was sitting in an attic office in Ealing Broadway when I received a call. The call was about a murder that had taken place on Wellhall Road. Stephen and his friend Dwayne Brooks were trying to get home at about 10:30 p.m. They were set upon by 5 or 6 white racist youths. One of them shouted, what nigger?" Stephen was able to run some 200 yards before he collapsed, a testament to his physical prowess. But he had 2 major arteries severed. Blood was pumping at a rate of knots. He collapsed outside a house where a young girl, 14-year-old young girl, came out, and when the police arrived, she said, "I've got first aid training. I want to help." Neither the police who arrived at the scene offered any assistance to Stephen as he lay dying, bleeding, nor did they allow this young girl who had first aid assistance to assist in any way. It's no surprise then, perhaps, that Doreen, many years later, said that those police officers did not want to get their hands dirtied with a black man's blood. Within hours of that murder, suspects' names came flooding into the incident room, but no arrests were made. A surveillance operation took place at the house of those who were named. Yet that surveillance operation did not have the power or the ability to stop individuals who were taking black bin liners out of their homes, possibly, probably, with blood-stained clothing. It wasn't until the arrival of Nelson Mandela in this country on the 6th of May 1993 that things started to change. Because Doreen and Neville and the family met Nelson Mandela, and he was interviewed on the BBC News. For the first time, the Lawrence case was the first item on the national news agenda. And Nelson Mandela was comparing apartheid South Africa to Britain when he said perhaps in this country, like apartheid South Africa, black lives were cheap. The next day, arrests were made. Nothing had changed from the 22nd of April to the 7th of May. The police felt the pressure of a leader, a global leader in our world. Individuals were arrested. 2 months later, charges were dropped. I had to make, and I don't know whether Doreen recalls this, I had to make one of the most difficult calls in my career as solicitor. I was informed by the CPS that they were going to drop the charges. Doreen and Neville and her family had gone to Jamaica to bury Stephen. I received the information the charges were going to be dropped. Doreen and the family wanted good news. I was the bearer of bad. I had to tell them. Charges were being dropped against those individuals suspected of Stephen's murder. I can't imagine what they must have felt like on the day, at the time, when they were burying Stephen, thousands of miles away. But that's what happened. Now, I had done practical law at university. I was involved in community law as an activist. And what the family wanted to know from me when they came back, you're the lawyer, what do we do? How do we go forward? It was quite simple as far as I was concerned back then. The CPS charge, the police arrest, CPS charge, you go to court, you get a conviction. It wasn't happening. So we came up with the idea of public inquiry. The Human Rights Act wasn't in place back then. And what we did, about 14 of us, Doreen wasn't there at the time, most of the family, a whole group of black individuals arrived at the Home Office and sat around a wooden table in a boardroom at the Home Office with a whole group of white ministers and civil servants. And they looked at us and wondered what the hell was going on. We said we want a public inquiry. It was a Tory government. They said no. And that, as far as I was concerned, the family was concerned, was the end of it. Now, people say, well, you must have known about private prosecution, things should have happened, and all the rest of it, and you could have done something about it. Just imagine the scenario. You've had an investigation. CPS have decided there's going to be no charges. There was a further investigation. Nothing came about of that. There was the audio-visual probe in the individuals' houses, which showed that racism, which some of you may have seen in the last trial. Nothing. CPS said there's going to be no prosecution whatsoever. I happen to be a defence lawyer, though known for prosecuting in this case. In 1994, I was defending 6 Bengali youths who'd been arrested for another murder, a murder in Somerstown in King's Cross. That received far more publicity than the case of Stephen Lawrence back then. His name was Richard Everett. Princess Diana went and laid some flowers at the point that he was killed. Within hours, 6 Bengali youths had been arrested for the murder. They were all charged. We ended up in court. The evidence against one of them was we did it in it. That was it. I, at the time, knowing as I did that there was probably some racism within the criminal justice system, I thought, how can we reconcile the fact that a white individual has been killed and individuals of a particular background have been charged and prosecuted in circumstances where the evidence meant that they should never have gone to court. At the same time, in circumstances where we have a black victim and the Crown Prosecution Service is saying there's insufficient evidence to charge, I found that difficult to reconcile. And the CPS lawyer, Howard Youngerwood, in the Lawrence case, said at the inquiry that took place much later that he sent me a letter apparently begging me not to take on the private prosecution. The same CPS who decided they would prosecute this young Bengali man whose case was thrown out in court eventually. Now, that is irreconcilable. And there's been much criticism of the private prosecution and much anguish, certainly on my part and the family. But I'm jumping the gun. Nothing was happening. We had an inquest in February 1997 at which the suspect, so-called suspect, gave evidence. But key in that particular case, particular hearing, was a question and answer session which led to many millions of pounds being spent for a public inquiry and what happened thereafter. During the course of the private prosecution, we had the assistance of the police officers. We had all the prosecution statements, we had all the unused material, we had everything that we understood was the evidence against those suspected of Stephen's murder. And we could tell that there were many, many holes in the way the police had acted, many failures. And we expected the police officer who had been assisting us to be able to accept that. And so he gave evidence in court, and Michael Mansfield, acting on behalf of the family, asked him a question, and we thought the answer was straightforward. He said, now that you know what happened during the course of the investigation, do you accept that anything had gone wrong? His answer was no. And Doreen, when we came out of court, for the first time, said, I can't believe what's happened. We need to put a complaint in against the police. And we did, for the first time. And this was 1997, 4 years after. Though we were complaining about what the police were doing, it was the first time that a formal complaint was put in. That complaint was investigated by a neighbouring police force, Kent, and they found some 14 lines of inquiry that the Met had failed to follow. That answer then led to a meeting with then Shadow Home Secretary Jack Straw. And Jack Straw will deny this to his dying days, but at that meeting, he promised a public inquiry should the Labour Party get into government. So I certainly, I don't know about you, Doreen, I went out and I started campaigning for the Labour Party to get into government. In fact, I stood against them. That's a different story. Jack Straw, true to his word, I don't know whether you remember the iconic footage of Cherie Blair coming out at number 10 with her hair all messed up and receiving flowers. I remember that day, not because Labour Party had got into government, because I remember the promise that Jack Straw had made. And he was true to his promise. He, on the 31st of July 1997, he ordered the inquiry and appointed Sir William Macpherson to chair it with 3 advisors, one of whom, Johnson Palmer, is probably going to be the next Archbishop. The public inquiry sat at the Elephant Castle in that horrible pink building that was the bane of my life for 69 days. It was awful. It was on the second floor, fourth floor, I can't remember now, fourth floor. In 1998, sat for 69 days, heard from 88 witnesses. I was witness 88. It was a strange day for me, and I speak as a lawyer, because I was representing the family, and Michael Mansfield QC was representing the advocate. But as I walked into that room, there were rows and rows of desks with eminent QCs representing all of the police. And at inquiries, you're told in advance whether criticisms are going to be made of you. None of them, the police, could criticise Doreen and Neville. They dare not. But me, I was an anti-racist lawyer, a term of abuse back then. There wasn't such things as human rights. And somehow they thought that because I answered the phone at 1 o'clock at night, that I wasn't just a professional lawyer who put the phone down at 5 or 6 o'clock. The community lawyers were somehow different. They somehow went the extra mile, but not for good reasons. Because police officers, I knew from rumours, would suspect your reasons for assisting in these cases. You're not doing it for money, so what is it? It must be something else. Anyway, as after police officer gave evidence, the police officers, barristers would say to them, so was it Mr. Khan who hindered this? So was it Mr. Khan who did that? And I was pleading with Michael Mansfield, saying to him, aren't you going to put my case? And he said, no, I'm the lawyer for the Lawrences. And I tell you this for this reason, that Mike did such a fantastic job, Mike and Steve and the other barristers who were there, that by the time I gave evidence on day 69, the whole atmosphere had changed of the inquiry. It had changed the nature of the lawyer representing a family. And there was one question that I remember answering, which drew a bit of amusement from the crowd sitting there. Because Michael Manderson would start with every witness, every police officer, and say, do you accept that anything had gone wrong with your investigation? And every police officer would say no, obviously. By the end of the cross-examination, Mike would have listed 22, 23, 25 failures. It would be highly embarrassing. So I was asked that question. Mr. Khan, did you do anything wrong? Or in fact, it said, do you regret anything that you did? And I said, yes. And my supporters of the public gallery were aghast. What's he going to say now? Because I'd been accused of being really hard on the police. That I was constantly sending them letters and bombarding them with phone calls. And so there was this pregnant pause. And so counsel said, well, what was it? And I said, I wasn't hard enough on the police. And the truth was, my job as a lawyer representing the family was I needed to ensure that individuals were arrested. And I didn't get it. And I didn't get the information. More importantly, what developed from there was that an anti-racist lawyer, a human rights lawyer, an activist lawyer was not a badge of dishonour, but a badge of honour, because it meant that you were fighting on the side of justice. And that, to me, from a lawyer's perspective, was a critical change in the way that the inquiry developed. But it wasn't just the recommendations of the report that came out of it. It was the fact that the family, for the first time, was able to ask questions of one of the most powerful institutions in society. It came out with 70 recommendations, but for me, the critical thing that it came out with was a mantra that I called of recognition, acknowledgement, and acceptance of racism. And again, some of you are too old, and you're way too old, but some of you are young enough not to remember what 1993 was like. But the idea that you could go to a police officer and convince them that racism was somehow part of the story behind an attack was just inconceivable. It just didn't happen. And so now racism became official. Not only that, but the Daily Mail got involved. The Daily Mail that was in the heart of Middle England and society. What now happened was that everybody knew. The problem was not now with the black communities, but it was with the institutions. The problem didn't lie within those communities. The problem lay within society and the institutions that dealt with it. And so what we had then, subsequently, were government reports about institutional racism within the CPS, within the health service, and so on. Institutions around the country were attempting to recognize, acknowledge, and accept the concept of institutionalized racism. And so what Sir William Macpherson ended up doing is defining or redefining the whole concept of institutionalized discrimination and racism. And in my travels talking about this case, I came across a lot of different examples of how one might explain it. And one of the most slightly bizarre ones, but interesting ones, was this. A baby food company was having some difficulty selling its product in a largely black community. And to deal with the problem, the designers looked at the product afresh and noted that the wrapping portrayed a blonde, blue-eyed baby. The answer, it seemed to the designers, was to change the wrapping, which was speedily done to reflect its potential customers. Unfortunately, it had little effect. Sales were still low. The designers, as I say, went back to the drawing board and pondered the problem until some bright spark realized that it wasn't the wrapping that was affecting sales, but the actual product inside the container. It was awful. The point is that far too often, when we deal with issues of race, there is a cosmetic approach to solving the issue. And what you need is the scaffolding propping it up to be dismantled piece by piece. And that is the concept of institutionalized racism. You've got to get rid of the structural basis upon which racism is based. And the reality is that in the years after the Lawrence inquiry, organizations have accepted the obvious truths of what happened. But there have been those who say it's political correctness gone mad. They're pining for a return to ignorance pre-Macpherson, pre the Lawrence inquiry. And what I say to them is, I paraphrase a Turkish proverb: the caravan has moved on and those left behind are just barking. I'm actually not sure quite what that means, it just sounds nice. But see, institutional racism isn't about lone individuals, it's about structures. And it's about the government, and it's about those who are in leadership positions, because we are all, you in this university as students and alumni who are working in an environment, you're all influenced and guided by the political culture around you. And that political culture is set by declarations, laws, edicts, which sets the tone, the tenor, the climate of race relations in society. And I can't forget, at the inquiry, part 2 of the inquiry, Sir Paul Condon, who was then the Met Commissioner, came along, and he was asked by Richard Stone, who was one of the advisors, he said, a bit like that anti-drugs campaign, just say yes, just say institutionalized racism exists, and he wouldn't accept it. And Richard Stone said, just say yes, and some burden will be lifted from your shoulders, and he wouldn't accept it. He wouldn't accept it. And the Commission's reluctance was noted in the report, and this is what it said. It's quite an interesting phrase, an important one. There is a small but significant difference between acknowledging that such features, racism, can exist, and acknowledging that they do exist. There must be an unequivocal acceptance that the problem actually exists as a prerequisite to addressing it successfully. You have to accept it before you can deal with it. I know that sounds trite, but I'm a lawyer who started in 1991, many years ago. And it may be now that there is that acceptance. And people say to me, well, have things changed? Yes, they have. Not that racism doesn't exist. It's just that now we have the structures, the laws, the armory, the ability to make sure that we can do something about when it raises its head. But just dealing with this unequivocal acceptance, because what it raised was what's called the reality spectrum. And in this audience, I suspect that there are those who've gone about their daily business and experienced racism on a daily basis. There will be others in this audience who've never experienced it at all and don't know what we're talking about. That's the reality spectrum. And let me give you an example. Again, part of the inquiry. What would happen would be police officers would come to the inquiry, give evidence to Sir William Macpherson, and in, I think it was West London, a chief superintendent came along and gave evidence. He said, oh, my area is fantastic. We're doing this, we're doing that. We're doing a brilliant job dealing with racism on our patch. He gave evidence at 10 o'clock. That afternoon, as we sat there, we listened to a middle-aged Asian man who began by saying that on listening to the police officer's evidence that morning about the wonderful area he was policing, he decided that he would move there straight away, only to realize that he'd been living there for the last 30 years. For years before the Lawrence case, before what Doreen and her family did, as I said, we had fought a losing battle with police officers and the prosecuting authorities to accept that race attacks were being perpetrated. It was an uphill task. And rather than being protected, the victims were being persecuted and prosecuted. One of the cases I first became involved in was called the Newham 7 case in Newham, East London, where 7 young Asian lads protected themselves against racists. And they were prosecuted, and they faced a case of violent disorder at the Old Bailey were acquitted on the grounds of self-defence is no offence. Those were the days. And no amount of pressure from me or anybody else could change that. And then along comes Doreen. The cultural atmosphere of the time was impervious to the concept that some of us now take for granted. It wasn't until Stephen was killed that that perception started to change. And that has led to real potential for change. The paradigm has shifted so that now racism exists within the police service, not within the black communities. That's where the problem lies. But more significantly, and I will start winding up, is that the paradigm shifted. That victims' rights now became far more important. And not only did Jack Straw introduce or set up the Lawrence Inquiry, but his government promised us what I think is something we must cherish, the Human Rights Act, which is under attack. And that is a paradigm shift which comes directly on the back of the Lawrence case. And if you don't believe me, it's worth reading some of the judgments that came out post-Lawrence, particularly the Zaid Mubarak case. And what it did, it changed the concept of the victim into protagonist. So now, I don't ever describe, never describe Doreen as a victim, though in reality she is. I'm sorry to talk to you about it in this way. But Doreen is a protagonist who can use the Human Rights Act to assert positive rights. So in 1993, when the family came to me and said, Imran, we want an answer, we want a solution, had I had the Human Rights Act then, I would have been able to challenge the government not holding a public inquiry and had that public inquiry in 1993. On October the 2nd, 2000, the Human Rights Act came into force. It led to other cases being incredibly successful. And one of the ironies, one of the difficult journeys that Doreen and I have had to face is that when I've done those other cases, I've gone to Doreen and said, what a success. And you could see in her face the bittersweet moment. Pleasure that somebody else has been successful on the basis of what she has trailblazed. But on the other hand, in knowing that the family has not achieved justice. One case that most of you may have known about is the Zaid Mubarak case of a young man who was killed in Felton. 6 hours before he was due to be released, he was attacked with brutal ferocity by his psychopathic racist cellmate. He was so badly beaten that his family could not recognize him when he was in hospital. And they could have taken some comfort from the fact that he didn't know that he was being beaten to death, except that we know that he was alive during the course of that beating because there were defensive injuries on his forearm. The simple question for the family was, why did you put a racist psychopath in with an Asian inmate? It took an internal inquiry, a CRE investigation, Court of Appeal, and then eventually the House of Lords to order an inquiry in that case. And I ask you to read that judgment because it encapsulated in Lord Bingham's judgment, the most senior law lord at the time, what precisely the family was saying. The Lawrence family was saying from 1903, something's gone wrong and we want to make sure it doesn't happen to others. And Lord Bingham, in his judgment in the case of Amin and others in the House of Lords, said precisely that. That under Article 2 we must make sure that there are inquiries and investigations which not only discover discreditable conduct, but we make sure that the families wish that it never happens again, it doesn't happen again. But the fact is that these changes in the Zaid Mubarak case, changes in the prison service, the Lawrence case changing in the policing, the Victoria Columbia case changing social services, and all of those have produced profound change out of the selfless acts of the families. But it only takes place as a result of a death. It's only as a result of a loss that change seems to happen. And the price the family paid to pursue that is an unbearable one. As Doreen knows only too well, while she and her family did not achieve justice, many others did, and society benefited. I finish, I hope, just in the last few seconds with this. I was describing 1903 to you. I don't think my words are sufficiently powerful to be able to convey how life was then. Let me use the words of Richard Adams, whose son Roland Adams died in the years before Stephen's in the same vicinity. He said this: "No parent expects or wishes to outlive their children. When I came to Britain, I thought it was a Christian country with Christian values. When my son was murdered, his throat cut by a racist gang, I thought there may be some feeling for our grief. Nobody from the leadership of any of the main political parties wrote to us or called on us. Nobody from the hierarchy of the church came by. And whilst the police caught the killers, they did nothing to stop the hate calls that came day and night that told us how pleased the callers were that our son was dead." In January of this year, 2 individuals, Gary Dobson and David Norris, were finally convicted of the murder of Stephen. Doreen said then that it was partial justice. It was the culmination of 18 years of struggle, and one which I hope will result in a future in which those words of Richard Adams will never have to be repeated. And finally this, I want to take this opportunity, because I don't often get the chance, to pay tribute to Doreen for the perseverance and determination she has shown to achieve justice, despite the personal cost. I'm just a lawyer. This has been a job for me. It's a career. But Doreen has not shirked from her endeavours or balked at any obstacle, despite the many being put in her way. It's been a pleasure and an honour knowing her on what has been a bittersweet journey for me, but one which has given me a greater opportunity of knowing about Stephen and his short life, and the telling and the retelling of his stories by Stuart and Georgina. It's clear to me, as someone who has lived through the last 19 years, that Stephen's impact, his death, has been huge. He has touched millions of lives and changed many more, including mine. For that alone, I, all of us, and the rest of humankind are deeply indebted to him and Doreen Lawrence. Thank you for listening.
Imran, thank you very much. Our final speaker is Doreen. Do you want to speak from here, or do you want to do it?
Can I speak from here?
You can. Those of you who are standing, there are seats at the front. If you want to be really quick, come and grab them. But be careful on the stairs. It's not obligatory to come down, but it is allowed. And it took several years of meetings, including lawyers, to persuade the university to put that rail in on these steps, because they're very steep. And we kept saying, look, we're personal injury lawyers, we know there's going to be a claim. And eventually we got the handle. All right, if you're sitting comfortably, I'd like to introduce our final speaker, Doreen Lawrence.
Sitting here listening to lawyers speak, and I'm not a lawyer, I have no legal background, or just an ordinary woman, mother of 3, starting out on a journey of education. And so listening to Imran and his jokes, I'm sorry, but I don't have any jokes. My jokes are usually where I stand up on a podium, and the podium is so high you cannot just about to see me, so that's usually my joke. 19 years ago, I received the news that no mother ever wants to be told the death of their child. I would say this was the most difficult moment of my life, when I was told that my son Stephen had died, and I wanted to die also. Because of my son's killers, I had to bury my eldest child, and so started on a long journey for justice. There is no deeper pain or injustice a person can suffer than to know that they live longer than their child who had died a painful death. But my pain did not end there. Stephen's case is well documented and brought about many changes in institutions, in the law and in the community, One of the major changes is the double jeopardy that allowed Gary Dobson to be retried and convicted. Back in 1996, the judge of the private prosecution instructed the jury to bring a not guilty verdict on all those, including Gary Dobson, who was charged for the murder of Stephen. That was a dark day, and one I'll never forget. The inquiry in 1998 was a turning point in the history of Stephen's case. The inquiry gave an insight into the institutional racism that had plagued our society, and I believe was instrumental in Stephen's death on the night of the 22nd of April 1993. Over the last 19 years, not only had I had to fought for justice for Stephen, but other sons and daughters, to ensure a crime like this could not happen again, not to another person's family, although many families are still experiencing injustice. In the words of Dr. Martin Luther King, take the first step in faith. You don't have to see the whole staircase, just the first step. The day I decided to stand up for the memory of my son, I took the first step, never knowing whether I would ever get justice for Stephen. Not knowing if it would ever heal the pain of losing him. I took the first step only knowing that I had to. That I wanted more for my son's legacy than for him to be remembered for the murder and racism. I wanted justice for him to see the change in the justice system. I became Stephen's voice as he had lost his. Stephen was bright and would challenge all indiscrimination, so I became his voice. I'd like to think that Stephen would be at peace now. One of the most positive things to come out of Stephen's passing is the Stephen Lawrence Charitable Trust, set up in 1998. I founded a trust not only to give a meaning to Stephen's legacy, but to give every person who walks through our doors the opportunity to realise their dreams. The Stephen Lawrence Charitable Trust is a national education charity committed to providing opportunity and access to disadvantaged young people in fostering positive community relations and enabling people to realise their full potential. The Trust has been committed to supporting young people from diverse disadvantaged backgrounds to help them to break the social and economic barriers that stood between them and a career in architecture, the built environment and urban design, Stephen's chosen career. I have a personal stake in every young person who walks through our doors. They are my Stephens. I could not be prouder to say that we have awarded over 100 bursaries and having seen 8 of them qualified as architects. This is gratifying to see because we have been so successful with supporting and giving architectural bursary students. We are now looking to broaden to other professions where young people who are facing social economic barriers. Last year, for the first time, with the support of the Landscape Institute, 2 students received bursaries to study landscape architecture. Also this year, the Worshipful Company of Paviours will be supporting the Trust to award bursaries to study construction. We're also looking at other professions other than in the built environment. For example, law, finance, media, to start off with. Since Stephen's death, there's been a lasting legacy that has been achieved. I can say that there are many things that can be attributed to his name. We have a change in the race relation, the Race Relation Amendment Act 2000. The Act brought all institutions including the police, who had sat outside the law, in line. The law and sentences is another example of this. During the sentences of Stephen's, at the end of Stephen's trial, Gary Dobson and David Norris were sentenced at the age they were when they committed the murder in 1993. If the murder was committed after 2005, they would have been given a much longer sentence, even though they were only 16 and 17 years as they were then. As I have mentioned about the double jeopardy law, is where a defendant can be retried, as you law students will know, can be retried for the second time if there is new and compelling evidence. Before the law changed, Gary Dobson would have walked free even if there were new evidence that came to light. I've only mentioned a few, and I think you will agree with me that these are significant changes that had happened in the last 19 years in Stephen's name. Building the future for our children through the work of the centre is ongoing. Over the years, we have worked closely with local schools, colleges, delivering an educational programme from computer design programmes to building a robot that was part of an American competition. We've also run Architecture for Everyone, a programme partnering with a global architectural practice, delivering workshops up and down the country to young people who were looking to enter into the profession. The Trust has also delivered educational work for the London Development Agency. Valuing education, this programme ran until the funding came to an end. Our purpose at the Stephen Lawrence Centre is to help those who do not possess the tools to break down the social barriers, preventing them from reaching their and recognising their aspiration. We are all aware that there are invisible constraints, be it the cause of where they were born or who their parents were. I believe our young people have the character to be better than us, to forge new paths and to change our world. However, those beautiful minds need to be watered, fed, in order to grow. At the Stephen Lawrence Charitable Trust, every young person is a seed, and we are the watering can, helping to cultivate new generation of thinkers and aspiration of change. I cannot stress more implicitly how important it is to educate and nurture our children. I can only explain it like this. Education is an armour, the defence against the world, which can sometimes be cruel, sometimes harsh and trying. Education is the raincoat to shield them against the storm, the light against the dark. At the Trust, we understand that education is one of the most valuable commodities you can pass on to your children. The Trust offers an opportunity to improve young lives. The Trust is now going through the third phase of its life. Phase 1 was the initial work of the architectural and the built environment profession. Stephen had an ambition to become an architect. As part of Stephen's legacy, I'm determined to help young people with similar ambitions. The Trust is set up with the object of making architecture a related profession accessible to the country's most disadvantaged young people. The major part of the legacy has been funding bursaries for architectural students. The Trust has worked with key partners and professionals to enable them to understand how the profession needs to widen its pool of talent. A high-profile highlight of the relation has been the annual lecture of lecture at the Royal Institute of British Architects. Last year, the speaker was the international acclaimed architect Zaha Hadid. The world-famous architect was commencing Stephen and the work of the Trust. Over the years, many eminent people have commemorated. My pronunciation is really bad here. Past that.
Commemorated.
That's it. Stephen by delivering a lecture either on architecture or social issues. The inaugural lecture in 2000 was by the Prince of Wales. Since then, among others have been David Lammy, Trevor Phillips, Baroness Scotland, when she was Attorney General, Boris Johnson, debating with Una King. And I should say also Imran was part of a panel of discussion. This year, the new event of the Criminal Justice Lecture, introduced by Paul Dacre, the editor of The Mail, whose intervention had had profound impact in 1997 when they printed on their front page the faces of who we believed to be responsible for the murder of Stephen. He introduced to deliver the lecture was delivered by Sir Ian Blair, the former Commissioner of the Met. All these eminent people, the commemorates, still can't pronounce that word, Stephen's life. Phase 2 was the creation of the Stephen Lawrence Centre in Deptford, which was officially opened by Ken Livingstone in 2008. The building itself is a monument to Stephen. It is a beautiful award-winning building designed by the famous architect David Adjaye, with windows decorated by designed by Chris O'Feely. The power and beauty of the building strikes you as you approach it along Brookmill Road. It is what the building provides, which is central to Stephen's memory. The building's about providing opportunity for young people like Stephen, who are ambitious for their future, but for whom, because of the race or economic circumstances, find it hard to realise their ambition. England is a social immobility country, and the centre is equipped with the sort of space and staff and responsibility to enable young people to break down these barriers. In the second phase, the Trust has received a significant grant funding from public bodies such as the London Development Agency for the Centre with Young People. The Trust has just received an evaluation of the Youth and Creative Design project funded by the LDA. The report praises the tailor-made program for young people, focusing on promoting the involvement of underrepresented groups of young people in the built environment. In engaging almost 1,200 young people through this project alone, the Centre has secured a critical mass that has helped to become established with the local community in Deptford as a site of positive learning and inform the cultural expression. The Trust is now in its third phase of its existence. Because of the economic times, we no longer live in a grant-funded times, and for the charity like ours, public fund has become increasingly hard to obtain. The Trust has to make its own way as a visible commercial organisation. The trustees have been working very hard with the staff to make this transition, as it is a vital part of his living legacy for Stephen. Remains to champion for social justice. The issues for black students don't change rapidly. Less than 10% of the black students at the top Russell Group University compare with a quarter of the white students. Black students are likely to achieve 24% less than their white counterpart. Similar statistics exist for the white working class students. We want to use our experience in the breaking through we've made with architecture in new worlds. As I have mentioned before, we are extending our remit to the legal and financial professions. Despite the outcome and the publicity of the trial, these are challenging times for the Trust. But we will prevail because it is so important to keep Stephen's legacy alive and to reinforce the tremendous impact of the work the Trust has done over the years in the name of social justice for all. Thank you.
Doreen, thank you very much for coming to speak to us. One statistic is that Southwark has one of the lowest take-ups of places in higher education from its school leavers anywhere in the country. So I think the work of the Trust, is very necessary and very welcome. And obviously, as lawyers, we think the world can't have enough lawyers, so we're glad that you're extending to law. And we also have projects in local schools and colleges where we try and work with people to encourage them into higher education and to imagine that they could enter the professions. I think we have a very few minutes for questions and comments, no speeches. But we have food and drink upstairs, not on the 8th floor for those of you who have been with us since the beginning, but just one floor up on the mezzanine. So we'll go there in a minute. But I would like to take a few questions or comments from the audience. Yes.
Thank you. Once again, I would like to say thank you to London South Bank for putting this conference together. My first question goes to Doreen. What were the sort of threats from the police or the CPS, if any, in terms of keeping you quiet about the very murder? And the second question goes to Mr. Imran Khan. Can you expatiate more on why the CPS want you to drop the case? Thank you.
Okay, so why the CPS wanted us to keep quiet, is that what you were saying?
Yeah, that's correct, yeah.
I presume they're not used to being challenged in the way in which we were challenging them around Stephen's murder. And I presume as profession, my understanding is that to speak into, I don't know, the CPS, I think they go through lawyers in order to speak to clients and that, but they're not used to doing any of that. And for me, I just think that because of what happened to Stephen, I wanted to know from them why they felt they couldn't go forward with Stephen's murder. When I was listening to some of the things that Imran was saying to me, that there's cases, if it's against a black person, they seem to take that to court, even though with less evidence and less information. So I didn't understand the difference. I think at the time we didn't know that they would have had so much information, especially the police, that they didn't use.
Can you hear me? Is this on? Yeah. What's quite interesting about Doreen is that as an advocate, when you're in a meeting, you tend to be the one speaking on behalf of your client. I didn't get a chance to do that with Doreen. And just by way of example, I don't know whether any of you saw after the trial, they reran a drama documentary that was filmed. And that was filmed ages ago. The character who played me was awful. His beard was terrible. It wasn't even that. That's by the by. I mean, Doreen was played by an Oscar-winning actress. I was played by somebody who I don't even remember. Anyway, the point is this, that some of my staff saw that and they said, you sat in a meeting, you didn't say anything in that drama. Is it true? It's not like you. And it was absolutely true. Doreen would sit in these meetings with police officers and say things which as a lawyer you think you just couldn't say because they came from them and they tried to stop everything happening. But Doreen and her family was so forceful, wouldn't take no for an answer and just wouldn't sit back. That's what they expected. And there were lots of meetings. They had chief superintendents and commissioners. I don't know how many commissioners you've been through, but none of them had the ability to do that. But they tried. In relation to this case, and why they wanted to stop it, when we did the private prosecution,
in those days, those of you who are criminal lawyers will recall that the defence could test the prosecution case against you at the committal stage, and therefore, if there was insufficient evidence for the case to go to the Crown Court, it'd be thrown out at that stage. So we thought, having laid the summons at court, that the point at which we would be found out if there was insufficient evidence would be at the committal stage, because there was a legally qualified district judge listening to the evidence, and if he thought, it was he in this instance, that there wasn't enough evidence, then the case would not go up to the Crown Court, and at least we would have tried. And we then expected, having the case being committed up, we expected CPS to then jump in and take over the case and carry on. And they didn't. And we were somewhat nonplussed. And it was, I think, for them an easy option to say, because it was difficult, don't take it. And then they could turn around afterwards and say, we told you so. It doesn't mean that their decision was right. And remember, it wasn't just me as a solicitor. I had instructed Michael Mansfield, and I think we had 3 other barristers on the team. We had the top scientists in the country giving their time for free, if not for peanuts, in order to look at the material. And all of that, we had not only identification evidence, we had fibre evidence. And what is so galling about what happened at the Court of Appeal is that the judge had the preliminary argument before the evidence could be put forward and ruled that the identification was inadmissible before the jury got to hear the rest of it. And one wonders whether, if that argument had taken place later, that the combination of what we had found, and you know, I don't remember whether you remember seeing those awful racist comments made by particularly David Norris. That was all there, and that was going to be put in front of the jury. And if that had been put in front of the jury, together with the identification evidence, together with the fibre evidence, who knows? And one can only speculate as to... I'm no conspiracy theorist, but you know, this was a black family from South London who'd taken on the state and had gone into court number 1 at the Old Bailey. And it just struck us as slightly odd, the way in which the judge operated in that case. But you know, that's history in a sense, and what's come out of it. Heartache for Doreen, but for society it's been much better.
No, I think you've had your go. Well, I'm going to take you, and you, and you, and then I'm going to wrap up. We're going upstairs. There's time for informal conversation afterwards.
Just to say thank you very much for all of the hard work you've all done. You know, I never knew about the case until very recently, and I was able to really look into the fact of the case. My first question is to you, Imran, and I just want to say that I absolutely agree with the issue of institutional racism. And I also want to say that I think I was wondering, how are these young people being radicalized? Because to me, it's radicalization. Basically, if they could go to that extent to do what they did, I think there's an element of radicalization. How do you think these young people are radicalized, and what do you think should be done? And the second question is to Doreen. We know already that the trust is actually embarking on projects to help young people from the black community. What is the core thing that you think needs to be addressed? The most important thing that you really think needs to be looked at?
When those young lads, when we first saw the transcripts of what those young lads were saying, in 1995 was the first time that we saw the transcripts of what David Norris and Gary Dobson, the A Courts, were saying in the confine of their own home. I'd been involved in anti-racist work for a few years. I thought I'd seen everything. And when I read the transcript, I was shocked at the degree of racism that back then they were 16 and 17. And I thought, what kind of society are we that allows 15 and 16 and 17-year-olds to be so racist by that stage? That was really shocking. You can understand that when people have lived a life and they've had experiences. What experiences could they have had which meant that they would cut up people and put them in a barrel and all that kind of stuff. It was shocking. And I was no less shocked when it was at the Bailey. And can I tell you this? We sat through most of the trial, during all of it, and you could feel the temperature change in the room when those clips came on. Because everyone knows about racism. Everyone understands it a little bit. You know, you see it on Celebrity Big Brother, you see it on Premiership football now, apparently, allegedly. But when you hear that, that is really shocking. And the temperature change. How do you change it? I don't know. The only way that I can answer this is, again, using Martin Luther King. For the moment, I think I can't change what people think of me. I can only change what people can do to me. So for the moment, I don't care whether somebody is a racist and thinks that towards me. For the moment, I'm just concentrating on what they can do to me. It's going to take generations to change people's perceptions of communities in this country. And there are cases, I'm not going to say it here, there are other cases where racism has become more subtle and new forms of racism come out. So people don't use the N word, they don't use the P word, but there are other subtler forms, sophisticated forms. People have found a way around it. We've got to be alert to that. So I think, to answer your question, that radicalisation is taking place because of surroundings, because of tenor, the government. Every time we talk about illegal immigrants scrounging off society, we're targeting whole communities. And it's government that's got to change the way that that happens. I'm afraid all parties are guilty of setting a bad position as far as race in this country is concerned. And what's great about Doreen is that, you know, the Home Secretary is petrified in her kitten heels when Doreen rings up and says, we want to do something about this. And I say, Doreen, use the power that you have to change the way in which race is dealt with in this country. And the other thing is this, it's not just race which has improved society. I sue the police regularly. Policing has changed in society. And it's not just policing, it's the media, everywhere else. Stephen's name has got into so many areas, and so many things have changed. So what's happened is good for all of society, not just certain sections of society. Yeah. But as a community which is, 30 times more likely to be stopped and searched, less likely to get jobs, less likely to get our education, etc., we've got to be extra vigilant that people don't say, racism, that was 1993. It's still here, and I can tell you that.
Things that I could change. I think one of the things I believe is that we need to start listening to each other and listening to what's affecting us. I think the majority is like when stuff was happening around Steve, nobody would want to listen. Nobody wanted to know anything about what we as a family was going through, and be it the police, the justice system, because he was a black person that was killed, nobody wanted to listen. And you start listening to about the young man that was killed over in Camden. The fact that when you hear about what happened and how quickly, I can remember our very first meeting in going to see at Paul Condon's office. I'm not sure if you were there with me, Imran. And one of the things that he was quick to kind of tell me what had happened to a police officer who was killed just after Stephen. And that, they have not caught his killers. But I wanted him to hear that on that night, they had helicopters, they had everything out, searching for his killers. On my son, they had did nothing. So don't you come tell me that there's anything the same. He had to apologise. I thought, how dare you speak to me? Tell me about someone else's when I'm here to talk to you about my son. Yes. So to think about what the core things, I think we all are from the human race, and we just need to listen. And rather than because sometimes part of things is divide and rule. And by saying, the Asian fan community is this, the black fan community, it's a divide and rule thing. And so we just need to be able to work together and to listen. Because if we don't do that, then you just keep repeating the same mistakes that we've made over and over again. We need to learn from it. And I think, the Conservative was in power when Stephen was murdered. it may be a coalition government now, but I still see them in power.
Yes.
You know, and they weren't listening then, and I don't see them listening now.
We are a community law school, and we are a community, and we can go and eat and drink together upstairs right now.
I mean, it's a great opportunity to be here tonight. I mean, I'm a student of Southbank University. I did my LLB here, and at the moment I'm doing my LLM as well. It's a wonderful opportunity to be here tonight, this evening, most especially to have the mother of Stephen Lawrence as well present with us here. Because there's one thing to hear about an incident happening, is another thing to actually have the mother of the victim with us here. So it's really a privilege, it's a great opportunity to really have her in our midst.
I thought it was great to get the two different perspectives. Obviously, Imran was covering like the legalistic perspective and the strategy in terms of how they won the case, and also you got the sense of like perseverance that was necessary over the years to actually come through and get the result that was needed. Whereas obviously from Doreen, you really saw the human aspect. So I think it was quite nice. Well, it was. You don't normally see it obviously unless you're with that client. It's very informative and emotional as well, I think.
I'm studying law here. I'm a third-year student now. Yeah, I mean, I've found today really inspiring. I'm meeting her herself, you know, in person, watching her there throughout her whole struggle. I mean, a bit before it'd always be behind magazines and what newspapers, the news, but seeing her herself and kind of being put through all of that is crazy, to be honest. And I mean, it was a really good time. I'm glad I came, and you know, I'm really happy to have met her and, you know, acquainted myself with her, spoke to her personally, and, you know, to give her that encouragement and to congratulate her for where she's come today. It's such a big thing.
Now, what I'm saying is that it is very, very encouraging to see that a practicing lawyer can identify an area of error in the law and how the police handle cases, including that investigation, and decide to take up the case and fight till he has success. Yeah, it's very, very encouraging to see that, and he inspires other younger lawyers coming up to see that they can do certain things without any financial benefits, just for the public, to see that the justice can be achieved, not just because of money. And secondly, the seal and the power that the Stephen Lawrence mother been able to use and fight and say that, oh, my son cannot die in vain, and decided to move all kind of muscles and power she could lay her hand on to a successful prosecution of the killers of her son. I mean, it is something that anybody will look at it and say, well done, at least you fight for your son.